Case number 1. Smith versus Hughes. Mr. Smith entered a contract with Mr. Hughes promising to deliver a large quantity of his oats. However, upon receiving the first batch of oats, Mr. Hughes realised that the oats he ordered were useless because they were green and not the old oats he needed to feed his racehorses. Hughes then sued for breach of contract, but the court's ruling was that Smith was innocent due to the following facts. Smith had given a sample of his green oats to Hughes, who approved of them and then agreed to purchase a large quantity more. Smith never said that the oats were not green or that they were old enough for racehorses to eat, and it was not part of the written contract that Smith would be selling old oats and not green ones instead. Lastly, the judges ruled that even if Smith had known that Hughes was mistaken about the oats, he was under no legal obligation to help him. So even if it was deemed to be a very unethical thing to do, Smith's silence about the oats was not illegal. One of the most famous 19th century judges, Judge Blackburn, had this to say about the case. In this case, I agree that on the sale of a specific article, unless there be a warranty making it part of the bargain that it possesses some particular quality, the purchaser must take the article he has bought, though it does not possess that quality. And I agree that even if the vendor was aware that the purchaser thought that the article possessed that quality, and would not have entered into the contract unless he had so thought, still the purchaser is bound, unless the vendor was guilty of some fraud or deceit upon him, and that a mere abstinence from disabusing the purchaser of that impression is not fraud or deceit. For, whatever may be the case in a court of morals, there is no legal obligation on the vendor to inform the purchaser that he is under a mistake, not induced by the act of the vendor. In the end, the judges all ruled that this was not simply about a meeting of the minds, or consensus ad idem, but also the conduct of the vendor. He didn't deceive anyone, and therefore was not guilty of anything, at the very least, in the eyes of the law.